Ghana is perhaps using, as it were, constitutional interpretation as a cover to assume complete jurisdiction or total authority when it comes to this area?
Let me express it in my own words. I am indicating that in that ruling, the Supreme Court failed to apply its own rules of court. And I mentioned Rule 46(2), which requires that when a plaintiff is coming before the Supreme Court with a certain matter in relation to seeking interpretation, seeking enforcement, that plaintiff must have a statement of case, and the facts and particulars that the plaintiff is relying on should be verified by an affidavit upon which the plaintiff is relying. There was no affidavit. The plaintiff admitted that in response to Mr. Sori's application. The Supreme Court's ruling does not tell us why the Supreme Court failed to apply its own rules of court, especially when there's a Rule 79 which says that non-compliance shall be a bar to further proceedings unless that non-compliance has been waived. And there was no indication that there had been a waiver. There are other fundamental issues. You know, in this plaintiff's writ, the article that the plaintiff was seeking an interpretation of was Article 97(1)(g). 97(1)(g). If you look at the writ, they did not include age, and that's a fact. They did not include age. So why was the issue of Mr. Honorable AC?
Whatever my fact me so video in my Charles Mamu and was I did say video no I very interesting at the amount and it's now video na baby do some pempens we na busu ani nyina say ensema hodo de bi koso ampo ensema koso issues ahodo e koso o social media so ase na ni nyina say yenso yensa ka bia yenda so yentena so ya adwen say e besi piano in fact pi tonsum pi dum kure baba ne baba besom e wo channel we so ne senti ana mensa aka e video ya me baba besom e wase meso so daroma obu ne ndi kwa so ene edidi nkan ana wo hwe e YouTube channel we ya now subscribe there mama we are now the bell notification icon so ato se be ya next time drop video pe once beka video ne 10 times so ebisenko ne nko video e enfambra.
So that's not a matter for the Supreme Court, or indeed that's not even a matter for the High Court exercising its powers in respect of fundamental human rights. So these decisions are there. There's more of them. I'm not giving a lecture to a law class, so I'm not going to go through those cases. But those cases are well known. So if the court constituted, recently wanted to depart from those judicial precedents, Article 1293 of the Constitution makes it quite clear that they have got to give us reasons why those decisions that they have given previously are to be departed from.
And indeed, I will come to you, Counsel. I'll come back to you. These are just your preliminary comments, just so you can continue. But essentially, what you're saying, and indeed the Chief Justice, when she was reading her ruling, as it were, mentioned that precedent of 2021 and even 2024. And still use that to justify her decision. And I'll come back to you. I just want Frank Davis to also give us his understanding of what happened. And I saw you kind of shaking your head when Mr. Chikata was submitting his point. What's your disagreement?
Good evening once again to your esteemed listeners and cherished viewers. I am going to lay my cards. I'm not in disagreement with anyone. We are espousing legal positions, so I need not be in disagreement with anybody. Okay. Now, your preamble, was a little bit confusing.
Mr. Imedwenchi, to connect with us, Mr. Chikata, you heard the CJ saying that, and the argument of the speaker was that I have not been served because per the law, I'm supposed to be served on Mondays. And the CJ, during her ruling, said that, yes, you're supposed to be served on Mondays, but also the law permits us to serve the legal department of Parliament any other day. Yes. and that was what she used to defend her stance. You've just heard the argument of Frank Davis here, as well as the counter argument from George Lowe. I wonder where you stand on it.
Our submissions.
I believe that the issue should not be looked at primarily from the point of view of the circular that the Chief Justice referred to. And by the way, the Chief Justice took it upon herself to make reference to some earlier circular of her predecessor in India, which was not before the court. It was not part of what was before the court. I think that it is really the Constitution that we ought to look at when we are determining these issues of service on the Speaker and the clerk. And it's quite clear in Article 117 that civil or criminal process coming from any court or place out of Parliament shall not be served on or executed in relation to the Speaker or a member of the clerk to Parliament while he's on his way to, attending at, or returning from any proceedings of Parliament. So the Constitution itself makes clear provision, and I believe that part of the reason that the circular was issued had to do with some discussions between the Chief Justice and the Speaker as to how this provision in the Constitution should be implemented. But, you know, I am more concerned with what I believe are fundamental problems with the ruling that was delivered by the Supreme Court. And I don't think that Mr. Davis has persuaded me that we're not allowed to comment on rulings that have been given because the judgment itself is going to be given on the 11th of November.
Of November.
A ruling has been delivered, and there are fundamental problems with it. I started off talking about, you know, the Article 99 reference, which you quoted from, you know, in opening. And there are a number of other points. You know, one of the issues that was put before the Supreme Court on behalf of the Speaker was that even the statement of case which was put before the Supreme Court in respect of the application, the originating process, it was not compliant with Rule 46(2) of the Supreme Court rules. And that rule simply says that there's going to be verification by an affidavit of whatever the plaintiff is bringing before the court. There was no such affidavit. And again, this was not in dispute because the plaintiff, in seeking to oppose Mr. Sori's argument, did not dispute that there was no affidavit. We didn't hear any response to that failure to provide an important element in the statement of case, an important element in the originating process. Now, the reason why that's important is because the rules of the court, the rules of the Supreme Court have a very clear in Rule 39, where the rules of court.
Your line.
Bar further proceedings under the court. Nothing in the ruling indicates that. Nothing in the ruling indicated the court had waived.
And you're breaking a bit. I'm sorry, Mr. Chikata, you're breaking a bit. But I just want to. Yes, I'm sorry, Mr. Chikata, you're breaking a bit. You're breaking a bit. We can't hear you clearly. But I want to understand, really, in the nutshell, what you're saying. You made a point earlier that you have fundamental problems with this whole ruling. And I just wanted to find out from you, aside from the procedural one, what exactly is that fundamental issue you have? Because I quoted earlier when I was, or Mr. Lowe was on the floor, that the Chief Justice said that procedure cannot override legality. So I just want to understand really if that is the point you want to make, disagreeing with the CJ. Okay, so we'll have to reconnect to Chachi Chikata. The line is not helping us today, but I want to kind of thought. But before you do so, though, listening to your argument before the line broke, is it fair to say that the Supreme Court of Ghana is perhaps using, as it were, constitutional interpretation as a cover to assume complete jurisdiction or total authority when it comes to this area?
Let me express it in my own words. I am indicating that in that ruling, the Supreme Court failed to apply its own rules of court. And I mentioned Rule 46(2), which requires that when a plaintiff is coming before the Supreme Court with a certain matter in relation to seeking interpretation, seeking enforcement, that plaintiff must have a statement of case, and the facts and particulars that the plaintiff is relying on should be verified by an affidavit upon which the plaintiff is relying. There was no affidavit. The plaintiff admitted that in response to Mr. Sori's application. The Supreme Court's ruling does not tell us why the Supreme Court failed to apply its own rules of court, especially when there's a Rule 79 which says that non-compliance shall be a bar to further proceedings unless that non-compliance has been waived. And there was no indication that there had been a waiver. There are other fundamental issues. You know, in this plaintiff's writ, the article that the plaintiff was seeking an interpretation of was Article 97(1)(g). 97(1)(g). If you look at the writ, they did not include age. And that's a fact. They did not include age. So why was the issue of Mr. Honorable Esiama even before the Supreme Court at all? Because age was not a matter that had been brought by the plaintiff. Not only that, the plaintiff did not include the NDC member for Amenfi Central in the people in respect of whom he was seeking certain orders of the Supreme Court. Yet the Supreme Court at the end had that member also included in its orders. So the Supreme Court in that sense is acting outside the framework of its own rules, outside the framework of the writ that was put before it. And that, I would like to say, is the reason why a former Chief Justice of the land can make the kind of comments that have been made, that, you know, it's predictable. It's almost like when and it's not only her, by the way. I mean, you've had a former, or a minister for national security also talk about Supreme Court decisions always tending to go one way. In other words, the issue of the partisanship with which adjudication is going on.
So if I get you correctly, what you're saying is that the last week's ruling kind of intensifies the perception that the courts are becoming more political than legal. That's what you're saying?
Well, I mean, absolutely. But as I say, I like to say it in my own words. And my words are to the effect that observers who are not, you know, members of the opposition to the government and observe
Okay, the line to Mr. Chikata just froze again, but we'll come back to him, wrap up with his thoughts and get the final word of Frank Davis as well as George Lowe. You're still here on Agenda on TV3. When we come back, we will look at one of the main reasons the chief mentioned, that the circumstance we were dealing with as at the time she was reading her ruling was exceptional, and mentioned the disenfranchisement, as it were, of these 4 constituencies. How do you respond to that?
Well, the disenfranchisement of anybody does not justify a Supreme Court not complying with its own rules when hearing a case, particularly when it does not give a chance to the defendants to appear for their side to be heard. The Supreme Court gave a ruling, as we call it, ex parte, without hearing the speaker. And the Supreme Court had every opportunity to hear the speaker. The Supreme Court chose not to hear. And you know, there are further problems with the decision of the Supreme Court. The application that was before the court was made ex parte, even though earlier on they had filed a motion on notice for the injunction order. Now, I mean, Mr. Davis, I'm sure, will recall, he, in a similar situation in respect of Honorable Judge Kwesi, tried to get the Supreme Court ex parte to give certain orders without hearing Judge Kwesi. And the first question he was asked as soon as he got up in court is, are you expecting us to make these orders without hearing? You know, I just happened to be in court that day. You know, we were not served. I was not there as a representative or as counsel for Judge Kwesi. But the Supreme Court itself found it appropriate that an order should be made for Honorable Judge Kwesi to be served before they would continue the hearing in respect of that matter. In this particular matter, the Supreme Court proceeded at breakneck speed with an application that was filed after midday on Friday. The Supreme Court doesn't normally sit on Fridays. Somehow the Chief Justice, you know, who is not all powerful, by the way, let's not, you know, when we talk about the Supreme Court having power to interpret and enforce and so on, it doesn't make them all powerful or infallible. The Supreme Court decided that on this occasion, without hearing the speaker or giving the opportunity to the speaker to be heard, they would proceed ex parte with certain orders.
So for you, that was double standard?
Well, I mean, there's multiple reasons why that is just not acceptable. But let me make a final point as far as, you know, the failures of the Supreme Court in its ruling are concerned. You know, the Supreme Court was faced with a so-called application to stay execution of the ruling of the Speaker of Parliament. Now, an application for stay of execution, as is fairly elementary within legal procedures, relates to execution of court decisions or court orders. The Speaker does not fall within the judicial hierarchy. And so that application itself was completely strange. I mean, let somebody, and, you know, let any judge or lawyer point me to where in any of the constitutional provisions, rules of court, Courts Act and so on, where the Supreme Court or any other court